Good afternoon, everybody. Welcome to the Hempposium stage here at Seattle Hempfest 2012. I'm Donnie Wertschafter, your moderator. And today I have a real job as moderator. We're talking about issue 502, which is on the Washington ballot in November. And never has an issue divided our community like 502. And we're here because one thing we can't agree on today is there's a lot of misconceptions. And hopefully here we can use the Hempfest energy to work together and work toward more consensuses, things that both sides can agree on. I mean, my shirt, my buttons here exemplify where we are these days. Okay, this is kind of Hempfest as a crew, Hempfest as a community, Washington as a state. We are in the middle. Yes, no, and you're hearing things from both sides. Today, we got extremely good panelists, all of them very capable of expressing their ideas here and telling you what they think is going to happen with this thing. We ask a few ground rules. We're producing this for video. We're doing everything by the cards. If you got a question, please put it down on a card now or as things come up. This is our goddess Pam here. If you look at the ambiance of this incredible symposium, we thank Pam, what we call the Pombiance. And she's made us feel welcome here and very much at home all weekend. Okay, so we ask you as panelists to keep it within the 66 pages of this initiative. You're all good attorneys or journalists, know how to keep things short. This is not about the people or the personalities or any of the actions that got us to this point. This is about what's going to happen with this thing. We ask you to keep it short. We don't want any stump speeches. Feel free to rebut something that you disagree with, but if you don't really need to rebut, just let it go. Again, the cards, we're going to take all questions by cards. There should be no audience interruptions, please. We ask you, this is for the video. There's going to be 100 times more people seeing this on video than here in the audience. We're going to do a quick straw poll. We'll do one at the end. You know, if the election were to be held right now, who would be on the yes 502 side? Okay. And who would be on the no on 502 side? And how many of you are undecided? You know, I'd say that's a third, and I think that's why we're here today, everybody. Okay. Let me introduce our panelists. Steve Elliott here is a columnist and a blogger. He writes for the Seattle Weekly and Toke the Town. And Kari Boiter is a legislative analyst and advocate, and the two of them will represent the No on 502 discussion. And on the yes side, we have Mr. Keith Stroup. Keith was one of the founders of NORML, the National Organization for the Reform of Marijuana Laws. He is now its retired executive director, legal counsel. And Alison Holcomb is a Seattle attorney. She's worked hard for the ACLU and for all the other projects that we've done to try to create drug policy reform here in Washington. And she is the field director, what's your title? Campaign director for the Yes on I-502 campaign. We're going to give everybody a chance to introduce themselves in their campaign and why they think that you should vote for it. And then we're going to get into the audience questions right away. So get your questions to our goddess Pam, and they'll get up to me, and they'll get asked for you, okay? Go ahead, Steve, you can start. And then we'll get Keith go, and then we'll get Kari, and then we'll get Alison, and then we'll get to your questions.
Okay, Test. Thank you. It's been quite a trip on this 35 years since I've been involved in the marijuana scene. I've seen a lot of things come and go. And I think one instructive thing to remember here is that I never in a million years imagined myself to be on any stage advocating against the passage of a marijuana legalization law. That is totally not what I'm about. I'm for freeing the herb for all of us. I want marijuana to be legal, no questions about it, for every man and woman of adult age. Now, having said that, let me say that this 502 is the only, quote, marijuana legalization, unquote, initiative that I have ever opposed in my life. I was for the rest of them. I was a financial contributor to Prop 19 in California. I was totally behind that. I know that some measures have flaws. I know that all measures have flaws if you look closely enough. I do believe that some flaws are too large to accept. Some costs are too high to pay. I don't think patients should be thrown under the bus in an initiative. It wasn't necessary. It wasn't necessary, and it didn't happen in Oregon. They have a good initiative. I totally support that. Mr. Paul Stanford is to be applauded for his efforts there. They have a good enough initiative in Colorado that I would vote yes there too. I'm not saying it doesn't have problems, but I would vote yes for legalization in Colorado. There's just too much wrong with this one. Thank you.
Keith?
If there's anything I can add to this discussion, it would be to try to bring a little bit of a national perspective. When you deal with initiatives or legislation, there really are two ways to look at them. For those people who live in the state up close, obviously that's an important perspective. But it's not the only perspective, because also these things have enormous impact on the national legalization movement. So I want to direct my comments briefly this morning to what I think I-502 brings to the national legalization movement. Now, let me start off by saying I concur, I recognize that most people who oppose 502, the primary issue that bothers them is the per se driving provisions of the 5 nanogram. And I will concede that I too oppose per se driving provisions. NORML has always opposed them. So I hope that this passes, and I hope we come back very quickly and improve that provision. But what I'm going to tell you is the reasons that I think it is incredibly important that this initiative pass, despite the fact that it is not perfect. I will obviously leave to Alison the details of the initiative, because she helped draft it and is most familiar with it. But from the national perspective, we really are at a tipping point for marijuana legalization. We now enjoy for the first time a majority support of the American public for full legalization, not just for medical use. When we founded NORML in 1970, Gallup poll had just done their first national survey to ask how many Americans support marijuana legalization. And in fact, it was 12%. That's what the support level was when we started off 41 years ago on this struggle. Well, as most of you know, in the last few months, we've had 3 at least credible national surveys. Gallup, that had 12% in '69, now says 50% support full legalization against 46% opposition. A Rasmussen poll, I think, came up with 56% support. And there was another one that's 52% support. And those are nationwide support figures, folks, which mean on the West Coast and East Coast, we have even higher. So for the first time in the 41 years that NORML has been involved in legalizing marijuana, we actually have won the hearts and minds of the majority of the American public, and that is terribly important. Now, I think most of us could also agree that the primary obstacle holding us back from finally breaking through and achieving legalization has to do with the incredible opposition at the federal level. We all know that Congress, they have their head in the sand with a few exceptions of people who are good, Jared Polis in Colorado and Barney Frank in Massachusetts, a few others. But mostly, Congress is still acting like it's 1950. They won't talk about it. We have 4 or 5 good marijuana bills pending in Congress. We can't get even one hearing because of the hostility of the Republican-led House of Representatives. So, what is needed is what happened at the end of alcohol prohibition. We need to have 1 or 2 or 3 states with the courage to stand up and say to the federal government, the hell with you. I am no longer going to spend my money to arrest marijuana smokers. And frankly, I don't know of any other potential action that would have that kind of seismic impact on federal policy. I mean, people talk about why don't we get 100 million people to come to Washington or whatever figures are. Well, number one, you don't get that kind of numbers to come to Washington. But number two, Congress doesn't give a shit how many people meet on the mall. They get paid just the same either way, and they don't pay any attention to us. But what happened at the end of alcohol prohibition was the state of New York led the way, and there were some other states that followed fairly quickly. They literally said, we're not going to spend our money anymore arresting alcohol drinkers in New York State. If you folks on the federal level, you want to do that with your federal resources, come on in. But we're removing our laws. And within a very few years, federal prohibition had come to an end. Now, I'm not suggesting that if Washington and Oregon and Colorado all legalize marijuana this year, that the federal government's going to flip over 180 degrees, the first year. Of course they're not. But what you will assure is if the state of Washington and the state of Colorado, I think those are the two where we have our best chance right now. I haven't seen the polling yet in Oregon, so I'm not certain. But it is going to be impossible for Congress to ignore this issue. They're going to have to start taking it serious. You're not going to have the president laughing again when someone asks him a question about legalizing marijuana, which is what we've been hearing from Obama. So what I would urge those of you who are registered voters in this state, and obviously if you live in this state, for Christ's sake, get registered, even if you're opposed to it, your obligation. This is an important issue and you've got to get involved. But I would say keep in mind the larger picture and the incredibly powerful impact it will have should this initiative pass. As I say, I know it's not perfect, but almost no laws are perfect. And all are subject to being improved down the road. But instead of trying to defeat this initiative, for those of you who are concerned about some of the provisions that are not great, I would say you will see that there's nothing in the entire legalization nationwide that can force a confrontation with the federal government and eventually lead us to the right to legalize marijuana than having some states come out and challenge the federal government. With the benefit of hindsight, I think we can all agree that the passage of Prop 215 in California in 1996 was probably the single most influential and important development in the marijuana legalization movement for the last 30 years. From my standpoint, the first big issue, the first most important thing, was the Marijuana Commission report in 1972, and then the 11 states that followed that recommendation and decriminalized marijuana. But then we went 18 years without another statewide victory until Prop 215 in 1996. Well, you folks in Washington have the chance now to have and create the next big important step in the legalization business. I-502 and the legalization initiative offers the opportunity to finally end marijuana prohibition once and for all. This initiative, if it passes, and I fully believe it will forever be seen as the defiant step that led to the end of marijuana prohibition. They will be writing about this in history books for decades. Don't make the mistake we made in California on Proposition 19. There, thanks to some degree to the infighting within our own culture, and especially opposition for some in the industry, frankly, who I think were fearful that somehow they might be hurt if we passed full legalization, and they felt they were doing pretty well under just legal medical use. But the result was we did pretty well, 46.7% I think it was, almost half, but we missed the opportunity to adopt full legalization because of some infighting, and with that defeat, Californians continue to arrest more than 50,000 Americans a year on marijuana charges, 80% for minor charges, that would have been legalized if Proposition 19 would have passed. And it will be at least 4 more years before we have the opportunity to do that again in California. That's 200,000 arrests that should have been avoided. Washington State currently has roughly 10,000 marijuana arrests a year. 8,000 of those 10,000 are minor offenses, which if 502 passes would no longer be criminal offenses. Don't set up the same situation where we have to wait 4 more years for Washington State to legalize marijuana, and we meanwhile we arrest 40,000 more marijuana smokers in your state because of that. So in closing, let me just say, let's stop fighting among ourselves about the details and move forward with the legalization of marijuana. We can do it. We have the public support. Let's just realize in the big picture, we can come back and fix the minor problems, but legalizing marijuana is what this whole drive has been about for 40 years. Thank you.
Alison? Kari next.
Test. So, I want to start out by finding out whether Oregon is ready to lead the way. How many of you here are from Oregon and are ready to lead the way on legalization? I think that Oregon can lead the way as well as Colorado. I don't think it has to be Washington. It makes me sad that Washington can't be the one to lead the way. I've worked pretty hard on it, like everybody else here, trying to legalize it. And like Steve, it pains me pretty deeply to oppose anything that's considered even close to legalization. I do agree with Keith that we need to follow the model of alcohol repeal, and that's part of the reason why I think this is way off base. Alcohol prohibition was repealed by removing it from the Prohibition and the Controlled Substances Act. This does not remove marijuana from the Controlled Substances Act. It creates a very narrow legal exception under which you can use marijuana, and you have to follow some very specific rules to do so. That would be fine with me, but the other problem that I have is that no other legalization initiative has ever put a new criminal law on the books to prosecute cannabis users with. That really gives me pause, because I already see what's happening with cannabis users and how they're being persecuted, and I don't want to see another law on the books that police can use to harass us with. So when I look at those things, it makes me take a closer look at the initiative, and it makes me read the initiative. And it makes me look at things like in the DUI part of the initiative, it talks about reasonable grounds. Now, I've heard New Approach Washington talk about probable cause being needed. I do not see anywhere in this initiative the words probable cause. I see reasonable grounds, and I in fact see a part where it says here that the sworn report under a declarized authorization authorized by RCW 9A 72085 submitted by a law enforcement officer is prima facie evidence that the officer had reasonable grounds to believe the person had been driving or was in actual physical control, etc., DUI. So what that tells me is all that has to happen is a police officer has to say, I believe this person was impaired. Maybe it's because they were a patient and it might be in their blood. Maybe it's because they're under 21 and the level they're setting for anyone under 21 is 0.00. That includes patients. If you have even the smallest amount in your blood, and let's recognize that the research that even New Approach Washington supports and recognizes shows that it can stay in your blood in measurable concentrations, active THC, for up to 7 days. And the research only went to 7 days, so we don't know how far beyond that it goes. So that's a real problem for people under 21, especially patients. We should also recognize that those under 21 are the ones being persecuted the most by police right now. They're the ones who are suffering. It's not us people who are old enough to understand how things work and live within the bounds. It's people under 21. And I don't want to give police officers another way to persecute those under 21. I got 5 marijuana charges on my record when I was under 21. That was without this DUI charge on the books. And let's recognize that if this commercial scheme comes into development and these stores open up, it's as simple as it is for police now to follow a DUI suspect from a bar and test them. They can follow you from a dispensary, and reasonable grounds is that marijuana they saw you buy, because 0.00, even if you are a patient, is illegal. I also want to talk about whether or not this can be fixed. If I thought it could be fixed easily, I would not be sitting here opposing it. Any initiative passed by Washington voters cannot be amended for 2 years. In that 2 years, how many victims will we see of this arbitrary, unscientific, and unnecessary DUI? And after 2 years, how easy will it be to fix this law? We have never seen a DUI law relaxed, ever, in the history of America. If you really believe that this DUI law will be relaxed, keep buying what Na's selling you. You know, I also want to talk about the divisiveness. If we don't even talk about what this bill is, the merits of the bill itself, let's talk about what it's done to our community. I am ashamed of some of the things I have seen, especially in recent days. And I really hope that this damage is not irreparable, because whether 502 passes or 502 fails, we have a lot of work to do. We either have to fix what's wrong with 502, or we have to pass another initiative. And there are other initiatives out there right now that don't have this DUI in it. And they include 514, which is collecting signatures right now. You can do something right now to put a legalization initiative on the ballot that does not have what NORML calls an unscientific, arbitrary, and unnecessary per se DUI policy. We are at the tipping point. We don't need to concede to federal law enforcement. We should wait, and it doesn't have to be 4 years. Sensible Washington next year is going out again. If we lose, and I don't think we'll lose majorly, I think it will be by a very small amount. That doesn't tell Washington or America that we're not ready to legalize. That tells them that there was just enough wrong with this initiative that it wasn't accepted, and we need something better.
Alison.
So I just have to take a moment for everybody in the room, regardless of what side you're on the issue or how you're feeling today about talking about I-502, to just recognize the historical importance of this conversation. For me personally, I'm shaking a little bit because I'm sitting next to Keith Stroup. And
He's an old guy.
And I first came to know who Keith Stroup was back in 1995 when I went to work as a baby criminal defense lawyer defending people charged with marijuana offenses and having their property taken in civil forfeiture actions. And that was the first time that I'd heard of NORML and the first time I'd heard of Keith Stroup. And it was just a few years later that, because I had the good fortune to work with Jeff Steinborn, I'd also got invited to participate in Hempfest for my first time and have been coming here for a little over a decade now. And it's kind of mind-blowing to be here having this conversation. When we look at what Keith Stroup and NORML started 41 years ago, and what this community here in Washington and throughout the nation has accomplished in that time, from the dozen states that decriminalized back in the 70s, through California passing medical marijuana law, through the rash of law enforcement priority ordinances passed across the nation, to Prop 19, bless their hearts, with the national drug reform movement saying, oh my God, don't you dare do that. We wouldn't be having this conversation here today if they hadn't. And so, yeah, I just kind of have to let you know that you should be really excited to be standing where you are right now. I just want to talk about 3 of the key features of Initiative 502 that I think weigh most heavily in favor of everybody voting yes of it. And this is without talking about the historical significance, the political significance, but just the substance of the measure. The first thing that will happen when Initiative 502 passes on November 6th is that 30 days later, on December 6th, it will be legal for every adult 21 and over in this state to possess up to 1 ounce of usable cannabis in bud form, 16 ounces of cannabis-infused product in solid form, baked goods, a pound, and 72 ounces of cannabis-infused liquid products, or any combination of all three. That will no longer be a crime. There will be no civil penalty. It will no longer provide probable cause for your arrest. You will be able to open your door if the police officer comes and knocks and not be afraid of the fact that you have cannabis in your possession. That happens December 6th. No matter what happens after that, that happens. The federal government can't change it. That is the state deciding that that is no longer a crime under the state law, and the federal government can't make that a crime again. The second thing that Initiative 502 does that a lot of people aren't really aware of, because we haven't been talking about it that much, is that it decriminalizes or legalizes industrial hemp under Washington state law. It does that by redefining the term marijuana, so that marijuana only applies now to strains of the cannabis plant that have over a certain amount of THC. It's the same standard that's been adopted in other countries. It's the same standard that's included in the Industrial Hemp Farming Act that's pending in Congress. Washington will decriminalize it. That means industrial hemp will be any other it'll just be like any other agricultural product in the state of Washington. We have some really fine Washington farmers here. We have a lot of fine farming ground east of the mountains, and so I'm excited about the possibility of finally allowing a domestic hemp production market to grow in this nation. And the final thing that I want to say about Initiative 5, what it does is, without touching the medical marijuana law at all, so without impacting patients' ability to grow 15 plants, to possess up to 24 ounces of usable cannabis, to create collective gardens with 10 patients and 45 plants and possess up to 72 ounces, without changing any of that at all, it finally gives patients two things that they don't currently have under Washington state law. The first is protection from arrest. In the state of Washington, we're the only medical marijuana state in the union that doesn't have arrest protection. In our state, all that patients have is an affirmative defense. An affirmative defense is something like self-defense. If I am being assaulted by somebody and I defend myself against them and I wind up seriously hurting them, I can be charged with assault, and I can go to trial, and I can raise the defense of self-defense. That's how Washington's medical marijuana law works. If I'm a patient that's completely in compliance with our law, I can still be arrested, I can still be searched, I can still have my home tossed, I can still have my property seized, I can still have my medicine seized and confiscated, and it can go away. All that I get to do is go into the courtroom and tell the jury that I'm a patient, and if they agree with me, then I walk away from those criminal charges. Initiative 502 will change that because it will make it legal for any adults 21 and over to possess cannabis regardless of why they're possessing it. And the second thing that it will do for patients is what the legislature tried to do, what the legislature actually did do last year before Governor Gregoire vetoed the provisions of the bill, is that it will create a system statewide of licensed, safe access points for all patients, so that patients who don't live in Seattle or King County can also have a place where they can go and know that they're getting a safe product that's grown locally here in the state of Washington and is subject to standards, quality control, and they know that they won't be getting marijuana that is not, or they won't be getting marijuana that's been infected with pesticides, mold, fungus. They'll have a safe access point to go to, because the regulatory system that will go into place will be available to all adults 21 and over, again, regardless of whether or not you're a patient. So I think I'll end with that so we can open up questions.
All right, thank you. Thank you, everybody, for your audience questions. We've already gotten over 50 of them. I'm going to summarize where they're going. If you got a question that isn't in the summary, go ahead, fill it in on a card, just so you know where the direction we're going to go in. We're going to talk about the DUI provisions, which has certainly gotten us the most questions. We're going to talk about the effect on home growers, the effect on medical users. We're going to talk about prices. Will they go up or down? We're going to talk about industrial hemp, please. We're going to talk about well, we'll get there. Changing state law with the federal pressure and those kinds of issues. What is the effect of this passing or not passing? Remember, all your questions go to our goddess Pam here, who will bring them up to me. So let's start with the DUI laws. This is, can you explain the DUI provisions in I-502, and how will this affect the patients?
Well, you heard Kari's interpretation of what the DUI provision does. So there's a lot of misunderstanding about it, obviously. Here's what you need to know, is that right now, under current DUI law, every patient, every cannabis user, every user of a prescription drug, every alcohol user is subject to DUI enforcement exactly the same way. If an officer has probable cause to arrest you, they first have to have some signs of impairment to pull you over. If they, through talking to you, observe signs of impairment, if they've observed driving that indicates that you're impaired, if they get to a point where they have probable cause to arrest you, they can take you in and they can give you a breathalyzer if they think it's alcohol, and they can give you the breathalyzer regardless of what they think it is. If the breathalyzer comes back at 0, or it's clear that the alcohol is not what is causing your impairment, they can then, right now, it's been this way for decades, take you for a blood test. And it doesn't matter to them what drug it is that they think you might be impaired by. They take the blood test. They have to stay with you that whole time because they have to maintain chain of custody of that vial of blood, and then they're going to send that vial of blood off to a lab. The police officer, throughout the entire process of this DUI encounter, never ever knows what your blood test is, never knows what THC, OxyContin, any of that. They don't have the ability to know that. It is not until the police officer sends the police reports off to the prosecutor, and the prosecutor reviews the police reports, and the prosecutor decides, you know what, I think I am going to charge this person with DUI, so now I've got to pick up the phone and I've got to call the lab and tell them to go ahead and incur the cost of testing that blood so that I know what the blood test result is. Then that information comes back. That's happening right now. Patients are being charged with marijuana DUIs right now. When that test comes back, here's what I-502 changes. When that test comes back, if that test is at 5 nanograms or above, the prosecutor can introduce that evidence at trial the same way the prosecutor would introduce evidence of a .08 test at trial. And then the jury can find you guilty of DUI solely on the basis of that test, should they choose to do so. Along the way, the criminal defense attorney who represents you will have the opportunity to bring a motion to keep the test out, whether it's because the criminal defense attorney says there was no probable cause to arrest you, there was no reasonable reason to stop you in the first place. So the criminal defense attorney can raise every defense that they raise right now in a DUI trial to keep that test out. The criminal defense attorney can also argue to the jury that they shouldn't believe the test results, that there was faulty taking of the specimen, that something was wrong at the lab, that it's a tainted specimen, or that you shouldn't believe the science. Even though they say that 5 nanograms is where you're impaired, you shouldn't believe it. And the jury ultimately is going to make the decision. What it changes is that the judge will tell the jury if the person came back with a test of 5 nanograms or higher, that in and of itself is proof that is beyond reasonable doubt that the person was DUI, and then the jury decides what to do. So that is what the DUI provision changes. So in fact, it doesn't give police officers any tools that they don't already have. It doesn't give the police officers the ability to profile you any more than they profile you right now. So how many times have we seen rashes of police officers pulling over people driving from dispensaries, driving from Hempfest. The degree of profiling that is happening right now is the degree of profiling that you can expect to happen after that test. But the bottom line is police officers have no way of knowing what your THC level is. It's the prosecutor who will know when that test result comes back if the police officer has gone all the way through the arrest.
Under current law in Washington State, as far as driving under the influence of marijuana, law enforcement must prove in the courtroom that a suspect was impaired to convict him. Under 502, they only have to produce a test showing that you were in excess of 5 nanograms per milliliter of active THC in your bloodstream, and that's what per se means. Under that law, you will be per se guilty upon the production of that evidence, 5 nanograms per milliliter. In other words, you don't have any more defense once that 5 nanograms test is shown in court. You're pretty much straight up and down, all like faintly weak arguments aside, you're going to be declared guilty, and that's the way it is. Now, why do patients have a problem with this? Here's the reason. 5 nanograms per milliliter is an arbitrary and unscientific cutoff point to indicate impairment by marijuana, especially among experienced users. And of course, this includes patients. And if you have patients who, for their own well-being and to feel like decent human beings, they need to medicate heavily every day, and a lot of my friends are this way, and I am too, then you're going to have to understand that we're a little bit uncomfortable with a law that effectively outlaws us getting behind the wheel of a car and trying to be a productive member of society. Now, when you wake up in the morning, if you are a heavily medicating patient, you are already over that 5 nanograms per milliliter limit. That's ridiculous. We are not impaired when we wake up in the morning. We're able to drive. We're able to be productive members of society. Now, here's the thing. My dad was a teacher. I think when you encounter ignorance, like this fear people have of stone drivers, you educate it. You don't legislate it. You don't encode that ignorance into law. It's wrong to pass a law that will hurt patients and make them less able to be productive members of society. It's wrong to pass a law that will certainly convict unimpaired drivers of DUI. How many innocent people convicted of DUI is too many? I think one is a little too much for my taste.
I might just briefly respond that in California with Prop 19, we had the benefit of some very sophisticated exit polling surveys. So we not only, knew what worked and what arguments a lot of people liked, we know from the people who voted against it why they voted against it. And we started off in that campaign with, I think, 58% support, and we fell during the campaign down to 46.7. I think the leading item justifying voting against that was the fear among non-smokers, not our culture obviously, but the rest of Californians, that somehow if we legalize marijuana without some special attention being paid to identifying and keeping stone drivers off the road, that there would be a vast increase in impaired drivers and it would be unsafe. Now, we all know that's largely exaggerated because the truth is those drivers were already stoned and they were already driving. They weren't stopping at home. But that's something we understand. It's not something those other voters who don't smoke marijuana understand. So again, the reason why initiatives like 502 have no choice but to pay some serious attention to that issue is because without it, you will not win, and that's what the polls show. So the question is, do you compromise somewhat so you can legalize marijuana, or do you continue to take a pure position and have a perfect bill, and you continue to lose it? And I think that's the choice.
No one's looking for perfection here in this legislation. was that? I'm not looking for the perfect. I'm just looking for good. And, you know, if people are so worried about this DUI law, first off, California is not Washington. And obviously, it's not a problem in Oregon or Colorado because there's no DUI laws in those bills that made the ballot. And if it's really a fear that we need to address, then we can address it by saying what Alison said earlier. DUIs are already happening for impaired drivers. Impaired drivers are already being stopped. We have a law that works now. We do not need to change it. Now, I want to talk plain language, what everybody can understand about what this does versus the current law. The current law, your blood test can be used as evidence. It's just one piece. They still have to prove beyond a reasonable doubt that you were impaired. And to get there, that would mean after you failed the breathalyzer, there's actually proof you're really impaired. Now, under I-502, it changes because instead of just being one kernel of evidence in the trial, it is definitive proof. Impairment is removed from the statute. You do not need to be impaired. You only need to be driving with more than 5 ng in your system. And let's not forget what everyone isn't talking about here, and that's the 0.00 for under 21. Washington voters already approved using marijuana for patients 18 and above under a doctor's recommendation. This doesn't make any recognition of that. If you're a patient or you're not a patient and you're above 0.00 and under 21, you are guilty of DUI. It does not matter if you were impaired. And maybe the reason they're not sitting outside of dispensaries now is because it's so much easier to bust people for possession now. And they can also bust people much easier for DUIs by sitting outside of bars. We know they sit outside of bars, so it must be pretty easy to bust people that way. And Alison mentioned that it was going to make it just like alcohol DUI, where it becomes definitive proof. So I also find that it's going to be less defense because, as I read from this report earlier, the sworn report of the police officer, that's one person, his sworn report, is prima facie evidence that you were impaired. That's all they need. They don't need to show probable cause. They don't need to show anything but him saying, I saw bloodshot eyes, that person was a patient and they were under 21. You know, they came from a dispensary. And chances are if you came from a dispensary, you're probably going to have some cannabis in your system. And the question is, do you know what your blood level is? I know what mine is. I wasn't going to oppose this bill without finding out and doing my due diligence to find out, am I really impaired at all times? Am I really above the limit at all times? I thought maybe the 5 ng was a reasonable cutoff. I wanted to make sure the research I saw was true. Because I'm a patient. I medicate at night. I have chronic pain. It keeps me from sleeping. You can ask my husband back there about how many hours of sleep I've lost, and worse, how many hours of sleep he's lost because of my chronic pain. I smoke a joint at night so that I can sleep because of my chronic pain. I went in after having smoked my normal average joint. I don't use medibles because they don't work with my digestive system, so there was no long acting. This was just simply inhaled marijuana. And we know that that's what gets out of your system the quickest. Let's not even talk about medibles. Those are there for a long, long time. So I went in and had my blood tested. I was 10.3 ng of active THC, 10 hours after smoking that joint, a full night's sleep after smoking that joint. Twice the limit they are proposing here for impaired. Now, those of you who might say, she had to have been baked. I don't know if you've smoked marijuana, but I've never seen anybody bake 10 hours later. But just in case, doing due diligence again, I had a medical doctor do all the tests that the Washington State Patrol would do, along with some additional tests to see. And of course I passed with flying colors. It was a night's sleep and 10 hours after smoking a joint. I was not impaired. But I was double the limit proposed in I-502, and that does not include the 0.00 for under 21. This is very dangerous. We are giving police a new tool to prosecute users under 21, and they are by far the largest group of cannabis consumers who are being persecuted here. The police don't need any other tools. Let's not go there with this. We can wait, we can find something better. This may be a new approach, but we need a better approach.
All right, thank you. Keep these questions coming. There's so many of them on the DUI. I want to revisit it. Just one more round on the DUI. So, to combine these, how would we fix, repeal, relax the per se DUI provision if 502 does pass? What would the process be to fix the 502 DUI provisions? Does the Yes on 502 campaign have a plan for fixing the 5 nanogram per se driving provision? And why not have a conversation about how alcohol and cannabis impairment are different?
There's 2 different ways that you can fix the DUI provision, depending on the context. The first is in the context of medical marijuana patients. So you can go into the medical marijuana law, and you can do this immediately in the next upcoming legislative session, which begins January 2013. The medical marijuana law currently says that being a patient is not a defense to DUI. You can add language to that provision that says, however, proof of your test result is not adequate evidence for a conviction, that you have to have additional impairment. You can do that right away, January 2013. And in fact, both Senator Jeannie Cole-Wells and Representative Mary Lou Dickerson introduced legislation in this past session to do that very thing. Now, that legislation did not get out of committee because we didn't have a per se law at that time. So it was actually prematurely introduced. Once a per se law is on the books, then there is a reason to pass legislation like that. So that's the first strategy. The second strategy is to be aware that Initiative 502 specifically dedicates funding to the University of Washington and the Washington State University to do further research on impairment THC. And thanks. With that research, we will have better laws. Now, there's a couple of points I wanted to make really quickly. First of all, is that I've discovered there's still a lot of misunderstanding about the per se's application. A lot of people think that limit applies to inactive metabolites like carboxy-THC, the metabolite that hangs out in your fat cells for days or even weeks after last use. It does not. It specifically applies only to the active THC that causes impairment. The second thing I want to say is that there is actually peer-reviewed science that says that when we get to the level of 5 nanograms, that is where we start to see the risk of crash increase beyond that of sober drivers. You heard Kari mention earlier that the research that is cited, and the research is available at New Approach Washington's website. There's a DUI backgrounder that cites the sources for all of the research. And Kari indicates that one of those studies shows that trace amounts of THC can be present 7 days later in active users. That was a study that studied heavy chronic daily users. And yes, there were trace amounts of THC found in a few of them at the end of the 7 weeks. Trace amounts, nothing close to 5 nanograms. None of the study participants were at 5 nanograms the day after they had started the study. And then the final thing that I want to point out is that in order to be really concerned that a lot of new people are going to be convicted using this tool, there's 2 things you want to think about. First of all, there are already 14 states that have THC DUI per se standards. 11 of those states are 0 tolerance. Half of those are 0 tolerance even for the inactive metabolites. If we were going to see a huge rash and unreasonable arrests of unimpaired drivers being dragged into court, we probably would have seen that in one of these other states that's a lot less tolerant of marijuana, like Utah, like Georgia, places like that. And we simply haven't seen that kind of rash of unreasonable arrests. And then the second thing is to remember that the people that are going to be impacted by this are those people that have been arrested for DUI, charged, had a test result come back at 5 nanograms or higher, and actually been acquitted. Because I'm here to tell you that what is happening right now in the state of Washington is that people who are getting charged with marijuana DUIs are getting convicted on carboxy results when it's clear that that was not impairing them at the time, at less than 5 nanograms. There is right now a man doing time in state prison for vehicular homicide who had a 1.6 nanogram result. There are not people who are getting charged with DUI and walking away from a conviction who have levels higher than 5. Think about how a jury responds right now. They have no standard, no guidelines, no way to know. All they know is this person used marijuana and got behind the wheel of a car. Think about how alcohol DUIs work. If an alcohol DUI proceeds and the test result comes in and says 0.03, the jury says, wait a second, 0.08 is where you're supposed to be if you're impaired. They have a guideline that might make them question whether or not this person actually was impaired. We have no guideline. So by default, just about everybody that goes to trial on a marijuana DUI, regardless of their test result, gets convicted. So there's a possibility that we'll actually see a reduction in marijuana convictions for DUI when juries have a reasonable science-based standard.
So we do have a guideline right now, and it's proof of impairment. They have to prove that you were impaired. That's pretty hard to do, and yes, there may be one man in there serving time for vehicular assault. There's going to be a lot more than one man, because there's going to be definitive proof at 0.00 for under 21 and 5 ng for those over 21. We don't need to dedicate more funding for research. Research has been done. Frequent heavy users were tested. I'm pretty much guaranteeing you that medical marijuana patients are on par with frequent heavy users, if not more so than frequent heavy users. And those frequent heavy users were self-reported. And I have the sheet right here. You can see this is from the New Approach Washington website. This is the Karshner study that tested people for 7 days. Never once did it go to 0. We're not talking about inactive. This is all of the types of THC. Active, inactive, COOH, Delta 9, it's all here. None of them hit 0. So if we're talking about impairment, why are we introducing a 0.00 standard for a wide swath of the population, including those approved by doctor recommendation? I also have here a report from a nonpartisan agency. This isn't the yes camp, this isn't the no camp. This is the Office of Financial Management. Their job is to be completely unbiased. And the very first thing that they say is that it would specifically prohibit driving under the influence of marijuana. The total fiscal impact on state and local government revenues is indeterminate due to the significant uncertainties related to federal enforcement of federal criminal laws related to marijuana. However, the initiative's provisions related to driving under the influence, which are not affected by federal criminal law, are estimated to generate known state fee revenue of $4,295,000. So if we're not going to see an increase, why does the nonpartisan agency Office of Financial Management plan on a $4 million increase in revenue? They go into it further to really explain why they think they're going to see that $4 million increase. And they say that administratively, as soon as you get this DUI, your license is revoked. That's an administrative thing. There's no hearing. It just happens. And they say, assuming an estimated increase of 4% in the DOL workload. So 4% in the DOL workload now. That's a lot of DUIs that we're going to see increasing according to the Nonpartisan Office of Financial Management. They don't have a stake in yes or no. They're just here to report what's going to happen. And they're very clear that they don't think there's going to necessarily be any money coming in from the commercial stores because they say the federal government continues to enforce its criminal laws related to marijuana, and it would impede the activities permitted by this initiative. But regardless of that, portions of the initiative pertaining to driving under the influence of marijuana take effect December 6th of 2012. She's right, it takes effect in 30 days after it's passed. And how long is it going to take to fix? We don't know. Yes, maybe Jeannie Colwell's plans to introduce a bill. I really hope that it gets leverage, because if this passes, we're going to have a whole lot of patients going down for driving unimpaired. I was unimpaired. I was at 10.3, active NG. It was not inactive. I am smart enough to have my blood tested for active and inactive. My inactive results were in the 40s. So that's my experience, and that's what I think is going to happen.
Can we go on, keep to Steve? Okay. So on a new topic, how will passing of I-502 have an effect on home growers and casual users? Why, under I-502, would passing a joint from a legal ounce be a felony distribution charge? How will law enforcement be able to tell state legal marijuana from illegal marijuana? And since the only marijuana legalized by 502 is marijuana produced with authorization, won't that make all other marijuana a Class C felony? And is therefore it not a advertised as legalization, but it's a decriminalization bill? Does it create a risky deception and erode credibility?
I think there were basically three questions in there: home growing, felony delivery, and the difference between legal and illegal marijuana. And I'm going to take the last question first. Initiative 502 does not distinguish at all about what kind of marijuana it is you're possessing. The legal status of 1 ounce, etc., on December 6th it does not matter where you got it from. There's absolutely no requirement that you be able to prove that you purchased it from a legal source. Doesn't matter where you got it. That's because all that it does is it amends the law that makes possession illegal right now. And it says basically, except for adults 21 possessing up to these amounts. And there's nothing in there that says that has been purchased from a legal source. So that's the law. With respect to home growing currently is a felony. If you are a medical marijuana patient, you have the affirmative defense if you're growing within the limits. None of that changes. So we did not, with Initiative 502, try to legalize home growing. And the reason why we did that is the years of research that we did in developing this initiative told us that Washington voters weren't quite ready for that. And you know, the same thing happened with alcohol. When we repealed alcohol, we didn't go straight there from everybody can distill gin in their basements. It's been a slow process. My strong belief is that once legalization passes in states in this nation, the fear around marijuana is going to drop exponentially, and that we will get to a place where we realize that people should be allowed to grow a little bit at home, just like they do with brewing beer, just like they do with making their own wine. Washington voters just aren't there in 2012, so we need to do what we can in 2012 and move forward rather than continuing to stay with the status quo. Finally, it is true, technically, legally, right now, under current Washington state law, passing a joint is a felony. This is because Washington state law only defines 3 crimes: manufacture, growing, delivery, which applies both to selling and to giving and to passing. If I give something to Keith, I have delivered it to him. And possession. Those are the crimes that are defined under Washington state law, and delivery is a felony. We don't change that, but when's the last time anybody in the state of Washington was charged with a felony for passing a joint? It's just a practical matter that I don't expect that we're going to see enforcement like that increase. I suppose that if the police officers that are walking around Hempfest wanted to bust us all for felonies, they could do that. But they're not doing it here. They're not doing it in Penderay. They're not doing it in Wenatchee. They're not doing it in Spokane. Nobody's going to waste felony enforcement resources on 2 people passing joints. Might they both get busted for possession? Sure, right now, after December 6th, no, they won't.
I can't speak for any of you, but for me, a lifetime of experiences has led me to have a certain distrust of law enforcement officials. What we are being asked to do is to trust the good intentions of the police force in all cases and at all times if we leave this much discretion up to them. If we have a law on the books, and if we have a law that I-502 leaves on the books, under which police can persecute marijuana users, I don't think we should be shocked when that's exactly what happens. We are leaving ourselves open to persecution from the police with this bad law. Keith talked a while about the message we would send to the federal government if we don't pass 502 in Washington. That might be faintly true if it were the only game in town, but it's not, people. We've got good initiatives on the ballot in Oregon and in Colorado. You know what kind of a message we need to send to the federal government? We need to let the federal government know we're not dumb enough to pass anything you call legalization, that only the good ones pass. Let Colorado and Oregon pass their initiatives, let this one go down, and let that be our message to the federal government. We're not dumb. Another thing that struck me as really irresponsible about 502 was that it passes the law against 5 nanograms. It calls that impairment, and then it says we'll use money to do the research. I think you need the research before you start arresting people.
Come on, audience. If this is from the last seminar, I had to write it down. If to be divided is to be conquered, then to be separated is suicide. We have a lot to talk about. So, besides the DUI provisions, how would the passage of I-502 change the law for the present medical marijuana patients? We're not talking about DUI here. How else would it change things for patients? Kari, do you want to go first this time?
Well, let's just say that these home grows that are currently quasi-legal under our law, they decide to register for the commercial growing for the state. I'm going to refer again back to the nonpartisan Office of Financial Management report, which says this initiative could ease federal criminal law enforcement activities by identifying marijuana producers, processors, and retailers. Now, how would it do that? When you register to grow or sell marijuana under I-502, you give your name, you give the address of where you are going to be growing or processing or producing or selling the marijuana, and you also agree to a criminal background check that can be given to the FBI. Now, if that criminal background check goes to the FBI, of course they want your fingerprints to go with it. That strikes me under the current situation we're seeing with the federal authorities to be ludicrous. Why would we give the federal authorities more information? It says specifically in I-502 that we're going to cooperate with the feds and that the state liquor board is required to cooperate with the feds. So yeah, it might make it harder for state authorities to prosecute, but they're not the ones I'm currently worried about right now. I'm worried about the feds as a patient. It's the feds who are making patients' lives hell, and this makes it easier for the feds to make it worse.
Don had to step back from the stage for a second. The short answer is that it doesn't change it at all. So Initiative 502 only amends Washington's Uniform Controlled Substance Act, which is RCW 6950. The medical marijuana law is 6951A. They're two totally separate statutes. Initiative 502 sets up a system whereby people who want to can get a license to produce and to sell for all people 21 and over, if they want to do that. It does not in any way impact the current medical marijuana law that allows for collective gardens. It does not in any way impact what a jurisdiction is willing to tolerate in terms of consolidation of gardens through safe access points. That is completely up to the local county and city electeds and what their level of tolerance is. As those of you in the community know, your experience in Seattle and King County is a heck of a lot different than in Kent or Bothell or Spokane, but that's all part of the medical marijuana law. Initiative 502 doesn't change any of that. If you're a patient, you want to continue to grow for yourself, collective gardens aren't quasi-legal, they're legal. If 10 patients want to get together and grow 45 plants and possess 72 ounces, there is nothing to stop them from doing that. That is the law. The questions that are out there right now is, can those patients collaborate and have safe access points and have essentially condominiums of various gardens in one location? And that is a your mileage may vary question depending on what jurisdiction you're in. None of that changes with Initiative 502. Initiative 502 is strictly about people who want to enter a commercial market to make cannabis available legally for all adults 21 and over.
Keep for Steve on that one. Okay, next. Does I-502 really change the law prohibiting industrial hemp production in Washington? If so, where is this going? And what will happen to the black market cannabis grown outdoors if industrial hemp production begins? First up can answer it.
I think we've seen what happens when you pass laws allowing the production of industrial hemp, and that is absolutely nothing. We already have several states that, by state law, the production of industrial hemp is legal. As long as it's illegal under federal law, you can expect federal raids of those fields once you try to plant them. So the problem as far as industrial hemp goes is getting federal legalization of that. And it's nothing but window dressing to pretend that we're going to have legal hemp growing under I-502. You can quote me on this, it ain't gonna happen.
Yeah, let me just take a little answer to part of what Kari said on her previous question and this one for Steve. Part of what I think what I certainly want to see happen from this, I want to create a conflict with the federal government. It's not illegal. It's not currently illegal to grow industrial hemp under federal law. It's illegal because the DEA won't give you the permit. And they're never going to give the damn permit until a couple of states get the courage to pass a law and confront them.
I think if you're going to create a conflict with the feds, you better be damn sure you're going to win. And we should follow the model of alcohol, which is to repeal completely, not create a small legal exception, and show that we are not going to allow our state and local authorities to be enforcing these federal laws. And that is the model that we know works, and that is not the model that I-502 is following.
I would say that the 17 states in Washington, D.C. that have medical marijuana laws, half of which of them license and regulate the production and distribution of marijuana, all of them which fly in the face of federal law. I'm really glad they didn't sit around and wait to find out if the Congress was going to give them permission or if they were going to win if they got challenged by the feds. They said, fuck it, we're doing it.
Okay, now we got a few questions. Maybe we can get some shorter answers too. How will the distribution system tax plan get implemented with the, quote, compliance with federal law, unquote, section of I-502?
The section that I believe that people are talking about when they're talking about the compliance with federal law is within the provision that relates to state agencies that regulate all of our drug laws. So Department of Health is involved, there's law enforcement agencies that are involved, there's another agency that I'm forgetting that's involved. There's a specific section that enables all of those agencies, that it gives them the legal authority to enforce our drug laws. And within that section there is already language that says, and they shall cooperate with federal agencies in enforcing drug laws. So what Initiative 502 did was simply add the Liquor Control Board, which is the regulatory agency for I-502, into that section. So there's no new cooperation requirement, if that makes sense. But the larger question is, what will happen? And that is the question that we all want to answer. when we drafted Initiative 502, we drafted it in such a way that we felt we gave ourselves the best chance of the federal government taking the same hands-off approach as it has with the states that have regulated medical marijuana. Some of you may not be aware that when Arizona passed its medical marijuana law, which includes robust licensing and regulation by the Department of Health, Governor Jan Brewer was the one who came in and sued, saying, preemption, preemption, we can't do this. And she also made the same arguments that Governor Gregoire used when she vetoed Washington's law. She said, our state employees are going to get arrested and prosecuted by the feds if we implement this regulatory system. The U.S. Department of Justice brought a motion to dismiss, arguing we have never threatened to arrest or prosecute a state employee for implementing the regulatory provisions of a medical marijuana law, and the judge granted DOJ's motion. So I think that we have drafted Initiative 502 in such a tight, responsible, regulatory way that the federal government is actually going to be politically in a tough place. Is it going to ride in and override the will of Washington state voters and say, yeah, that system isn't good enough and we don't think you're making the right choice, when not only did they come in and bring a motion to dismiss the Arizona case, but they stood by when Washington, D.C. implemented its regulatory medical marijuana law, and the laws of Washington, D.C. are subject to congressional review. Congress has 30 days to decide whether or not it wants to strike down Washington, D.C.'s laws, and it did not. So I think that it's time for us to call the question.
The federal government is not standing by in these medical marijuana states. They are raiding places. They just raided Harborside, the most safe and secure access point that exists. It is regulated, they pay taxes, and the feds just raided them. They're not standing by at all. I don't think they'll stand by on this one either, and neither does the Office of Financial Management. Let's again go back to the report, which says the federal government could choose to pursue criminal charges against state employees. So they're planning on the state incurring additional costs for the defense of employees for acts performed within the scope of employment. They've actually banked in money to pay for the defense costs for when employees get sued. Our own governor was worried about the same thing. Not Arizona's governor, our governor. The Obama administration promised not to prosecute and not to use federal resources to go after those in compliance with state laws. I have not seen that done. I have seen those in compliance with state laws to be persecuted at a rate higher than the Bush administration. I don't see them ramping down. I see them stepping it up. They are scared, and as soon as we implement this and we don't implement it right, they're going to nail us. We need to be very careful, and we need to do this correctly. Oregon and Colorado are poised to lead the way. We don't need to jump on with a law that is not correctly framed for this federal standoff.
Okay, we'll keep going here. Thank you, audience. These are great questions. Thanks for being so polite to our speakers here. It is my understanding that 502 strikes the definition of marijuana paraphernalia from the definition. Would this remove penalties for having a pipe?
Yes.
Okay.
That is correct.
Hey, we got consensus on that one. Do you think juries in Washington will actually convict anyone after 502 passes?
If you mean under federal law, well, the real truth is they don't have the manpower or resources. Something like 97% of all arrests in the country on marijuana and most criminal charges are state level. They're not federal. The feds don't have that kind of resources. So even if they were upset that Washington and hopefully Oregon and Colorado would legalize marijuana, in all of those instances, you're essentially removing these laws, these state laws, and so if the feds are going to enforce it, they're going to have to dedicate their manpower and resources to coming and arresting smokers. That's crazy, folks. There's almost no federal arrests now for marijuana smoking. They're all state. So the idea that the feds are going to come in and make up the difference, that's fantasy.
So what are the consequences if 502 doesn't pass? Are we better off here if this passes, or what are the consequences if it doesn't pass? Are we going to be like California where the feds move in?
The feds moving in California has nothing to do with Prop 19. They're moving in everywhere in every state. They just did it in Spokane, and it had nothing to do with an initiative passing or failing.
Okay. I was going to say, they're not moving in every state. New Mexico has had licensed dispensaries for 6 or 8 years, and the feds have never made a single arrest to a dispensary in New Mexico. So let's get over that bullshit.
I've heard it's be said that 502 fails to have a preemption clause or a severability clause. Are these defects that are going to make the whole thing come down?
No, because what Initiative 502 is that it amends our currently existing Uniform Controlled Substances Act, which already has severability and preemption provisions in it.
Anybody else? You agree on that, Kari?
I do want to respond to what Keith said earlier about the feds and the state laws. Let's be clear, this doesn't remove all of the state laws and state penalties for marijuana. This removes a very small, leaves a very narrow legal exception. It is not legalization, it is a legal exception. So there are still many things that state and local officers can arrest you for, and be sure they will be doing it.
If 502 passes, will it be a domino effect throughout the country? And are we creating a domino effect for our DUI laws if those two are going to be spread around the country?
If 502 passes as written, then that's going to be the green light to DUI provisions being written into every marijuana legalization initiative in the future. And that sets a really, really bad precedent for a number of reasons. The chief of those reasons is the fact that despite the fact that you were told earlier by a fellow panelist that 5 nanograms per milliliter has been definitively linked to impairment by marijuana, that is not true. In fact, there are good studies, more good studies, in fact, that show it is not linked to impairment. Not 5 nanograms per milliliter, and particularly not among people who are accustomed to using marijuana. I feel compelled to point out the fact that there is a scientific study that shows that medical marijuana patients, particularly those who are suffering from pain and nausea, drive better after medicating. That makes sense. If you're not in pain and if you don't feel like you're going to throw up, you're going to be a better driver after medicating than you were before. Well, there's a scientific study that shows that. You don't have to believe me, look it up.
I would say that if we were dealing with a state legislative proposal to legalize, and if it included weakened provisions, then I would agree with Steve that oftentimes what happens in the state legislative process, we've seen it in medical use, is as one state adopts a more restrictive version, for example, New Jersey had the most restrictive, then when DC came along, of course, they went for the New Jersey model, the most restrictive. But that's because you're dealing with timid elected officials. With initiatives, you don't have to put up with that. You have groups of committed, independent-minded people that come together and draft what they think will work. They're not running for office. So if, in fact, there's a consensus after the first year that the per se 5 nanogram was too restrictive in this state, no other state, when they draft the next initiative for full legalization, they'll know that, and they will simply avoid it. They'll improve it. So again, I do not think that the fact that you have a restrictive provision on DUI will be necessarily included in future initiatives. I do say this: if you fail to approve 502, for the rest of the world, certainly the rest of the states, but I think worldwide, they're not going to report it as oh, they almost passed it, but they had some questions about driving. No, the headline will be marijuana legalization rejected. And if you pass it, it will be marijuana legalized in Washington State.
I don't want to speculate on the headlines. I mean, I worked in the news media for 10 years. I would say that the headline will probably be marijuana narrowly defeated at the polls, because that's what's going to happen. It's either going to win or lose by a couple of percentage points. The other consensus that we have, and NORML agrees on it, they've issued an 11-page paper on it, is that, and I'll highlight from that 11-page paper, in some chronic users, THC may be present in blood for a period of days after past use, long after any performance-impairing effects have worn off. But let's not leave it to NORML. Let's talk about actual scientific opinions, like the Grotenherman paper that's published on NA's website that says scientific evidence on cannabis and driving is not yet sufficient to permit the selection of a numerical, that's 5 ng or 0.0 ng, that means numerical, enforceable THC limit with the same level of confidence as for alcohol. And then Karshner, also found on the NA website, says substantial whole blood THC concentrations persist multiple days after drug discontinuation in heavy chronic cannabis users. That's not talking about patients, that's talking about heavy chronic cannabis users. Do you plan to use cannabis daily if it's legalized? Yeah. That might be some heavy chronic use. We don't know how it's defined, but I don't want to find out when the cops charge me for DUI.
Just a few more questions here, and we'll wrap this up. Here's a questioner who's got concerns about the 1,000-foot limit from a school or park or a child care facility. Wouldn't that make it extremely difficult to actually distribute cannabis in any metropolitan area?
The 1,000-foot rule is the rule that is applied at the federal level in drug cases and was adopted specifically to deal with that issue. As we know, in Colorado, we've seen the federal government come after dispensaries that are operating within 1,000 feet of those locations. Without having mapped out every city in Seattle, I'm sure that there are places where you will not be able to have a retail outlet. I think that there will be plenty where you will be able to. It's just an issue of making sure, you know, the number one reason why a lot of people are uncomfortable about moving in the direction of legalizing marijuana is the impact on kids. And putting restrictions in place on advertising, on location of retail outlets, on ways that children are exposed to marijuana is very reassuring for people that would rather see us follow something that looks a little bit closer to a tobacco model than that of alcohol, where children are inundated with advertising for alcohol at all hours and all locations.
I'm just going to go ahead and give you straight from the I-502 text where you cannot have these commercial outlets or grow or produce or process within 1,000 feet of school grounds, a playground, a recreation center or facility, that's pretty loosely defined, child care center, public park, library, a game or arcade, admission to which is not restricted to persons aged 21 and older. I don't know of many arcades that are 21 and older, except for in Portland. Lucky them. It doesn't stop there. It also says on or in public transit vehicle or public transit shelter on or in a publicly owned or operated property. How many of you live within 1,000 feet of any of those places? Or how many of you have been to a store within 1,000 feet of any of those places? Good luck finding one that's not within 1,000 feet of any of those places.
Anyone? Maybe someone has a comment on this one. If 502 passes, how would it affect Washington's compliance with international treaties? Is this going to get us in trouble with international governments?
You know, I often hear people raise the Single Convention Treaty of '61, and when you read the history of marijuana prohibition, what you realize is Anslinger spent a lot of time making sure we signed that treaty because he thought he was locking us into a system that we could never get out of. even if we changed domestic policy, he would always stand up and say, no, international law. That single convention treaty itself says that if any party to the treaty wants to step away from any provision included, they simply have to give notice to the official agency, and 6 months later, you're not bound by it. Now, that's not easy. I wish we would have never signed the damn treaty. But the idea that we can't get out of it, if we ever get a Washington, D.C. administration that is at all rational and sympathetic to this policy, we will be out of the single convention treaty, at least to the extent that states will be free to legalize marijuana if they want to without putting the U.S. in violation. So that's a temporary sort of technical thing. It's not enforced in the first place. There's at least one country in Central South America that's already done it on some of their drugs. They've indicated they don't want to be held responsible. So we're not locked in by the single convention.
Finally, can you explain what got us into this divided mess? Generally, any successful political organizing campaign has a firm base to start from. How can 502 win when it isn't supported by its base? How did we get here? Why is this such a surprise on our community?
If I could weigh in on this one, it seems to me that for many years, the first 30 years at least of the 40 years we've been working on active legalization in this country, we all kind of agreed, or at least our culture, we favored legalizing marijuana. And it was an easy agreement because we didn't have to define precisely what we meant. It was a few years off. And so we kind of agree on, and as all of us on this panel agree on legalizing marijuana. What's happened is, in some ways, it's a reflection of the political success we've begun to have around the country. As you get closer to actual legalization, those details become incredibly important, and part of it is because you're dividing up the money. You're deciding how much money you're going to make and who's going to make the money and what kind of licenses and who's going to qualify. So, of course, people that used to be allies, and we still are on the big picture, will disagree on individual things. So I don't think it's different for our issue probably than any other issue. As you get close to success, the differences become far more important.
Well, that was the logical flow of the questions that came in. We didn't get to all of them. And they're saying we have some more time, so I'm going to try to get to all of them. Okay, so we're going to cover some ground again a little bit. And people want to know about field testing for blood and DUIs. And are these field tests accurate? And how many people are really going to get tested under this provision? And how different is this from if it doesn't pass?
So Initiative 502 doesn't change any field procedures whatsoever. All that it does is create a new blood standard after all the regular DUI provisions have been enforced. So currently under Washington state law, there is no requirement that you do field sobriety tests. There's no legal requirement to do that. Officers ask you to do it. The only reason that they're asking you to do it is to build a case against you. They want to be able to say that you stumbled when you walked heel-toe. They want to be able to say that you weren't able to get your fingers to your nose. So that's why they ask you to do the field sobriety test, because that gives them evidence that builds a case toward probable cause to arrest you. There is no requirement that you take the portable breath test that is offered to you when you are pulled over on the side. That too, again, is simply evidence that they can use to establish probable cause to arrest you. None of that changes. Currently, if they have probable cause to arrest you and if they have evidence that you've been driving impaired, they can take you back to the station. If you refuse to take the breathalyzer, you will lose your license for a year. If the breathalyzer shows evidence of impairment, everything stops there. The only way that you get to a blood test is if they have probable cause to arrest you, evidence that you're impaired, and you're impaired by something other than alcohol. They have no idea. I mean, they receive some training about what the signs of impairment are for different substances when they go through the Criminal Justice Training Institute. That's happening right now. They, for marijuana DUIs, I think one of my favorite symptoms that they look for is a green tongue. I love that. I guess because you mashed up the juice and rub it all over your tongue when you're smoking marijuana. I don't know what that's about. But if they have all that and it's not alcohol, they currently are allowed to require you to submit to a blood test. You can refuse, and again, that triggers the 1-year suspension. And at that point, they can choose either to proceed with the evidence that they've gathered from their observations, or they can call a judge and they can get a warrant and they can force you to do the blood test. That is current law. So none of that is changed by Initiative 502. Nothing has changed through all that process. The officer submits his reports, sends the blood test off to a lab. When the prosecutor gets all the paperwork, the prosecutor makes the decision about whether to proceed with a prosecution. At that point, the prosecutor will ask to have that blood tested to see what your level actually was, and that will be a piece of the evidence. And Kari is right. Right now, it's just a piece of the evidence. With I-502, what changes is that it is the piece of evidence that the judge can tell the jury that test in and of itself establishes your guilt beyond a reasonable doubt. That is how it operates, exactly like 0.08 on alcohol. Right now, with 0.08 on alcohol, that in and of itself is enough to find you guilty of DUI for alcohol. That's all that changes with Initiative 502. And again, remember, right now people are getting those blood tests taken, right now their tests are coming back, and right now they're getting convicted with lower than 5 nanograms, with carboxy-THC, with a whole range of tests. So the practical implication, I think, is going to be very, very minimal.
Again, audience, thank you very much for your great questions. We're going to wrap this up, giving everybody 1 minute to say their last thoughts, and go ahead. Start with Steve.
I would encourage everyone to carefully read I-502 and to think about the impacts it's going to have on the marijuana community here in Washington. Then vote your own conscience on it. I would also add that whatever happens in November, we're going to have some work to do, because marijuana is not legal until you can grow it yourself. Marijuana is not legal until you can have more than an ounce. Marijuana is not legal until you can drive the next day when you're unimpaired and not get arrested for it. And until we change those things, we don't live in a just society. I will not stop speaking out about it until we are there.
I concur with Steve and would just add that the alcohol impairment levels have some science to back them, and all the science we have on THC and impairment shows that the levels in the blood do not correlate to any impairment. They are not directly correlatable. That's the evidence that even New Approach Washington puts out. So again, read it very carefully, vote your conscience. If you know patients and you know casual users who are going to use daily, and you know people under 21, I have 4 sisters under 21, I can't do this to them.
I would like to say that I trust the audience understands that we disagree a lot on some of these policies.